criticizing him for leaving what may be a few hundred Americans behind after his troops left.
Since March, we reached out 19 times to Americans in Afghanistan with multiple warnings.
President Biden saying the U.S. will hold the Taliban to its commitment to let others leave when they wish and will go after terrorists who threaten U.S. interests there or at home. Andy Field, ABC News, Washington.
Republican lawmakers wasting no time in criticizing the decision. Texas Congressman Daniel Crenshaw is a former Navy SEAL.
The administration has to admit it's wrong. Stop running victory laps. It's like the arsonist claiming they did a really great job putting the fire out, when in fact there's actually still people inside.
Republicans say they've sent letters to the Pentagon, the State Department, and the intelligence community asking the agencies to preserve documents leading to the troop drawdown. They say that information will be part of a future investigation. Utility crews are working around the clock to restore service to hundreds of thousands of customers in Louisiana who lost power during Hurricane Ida. Governor John Bel Edwards.
Now is really the most dangerous time over the next week. Couple of weeks. And so we're asking people to be patient. We're asking people to be careful. And please be good neighbors.
The remnants of Ida now over Tennessee have forced the cancellation of this week's Bonnaroo Music Festival. The U.S. COVID-19 vaccination rates have doubled since mid-July. Coronavirus Response Coordinator Jeff Zients.
Back in mid-July, we were averaging 500,000 vaccinations per day. Today, we're averaging 900,000. That's an 80% increase in the number of shots we're getting into arms each and every day.
But hospitalizations are also on the rise. You're listening to ABC News.
From the KMET Weather Center for Beaumont and in the Pass area, we have a flash flood watch in effect for Tuesday. This afternoon, sunshine with a stray shower thunderstorm, high 98. Mainly clear with a haze developing tonight, low temperature 70. Sunshine Tuesday, straight thunderstorm, high 88. For the Inland Empire this afternoon, we'll have sunny skies, high 96. Palm Springs sunny with a stray shower, high 110. I'm meteorologist Jim Mullally for Smart Talk 1490, KMET.
Your Pharmacy and Mobility Solutions now has Pack Your Meds. That's right, just add water. You order 5 or more prescriptions from Your Pharmacy and Mobility Solutions, and they will pack your meds for you in AM/PM marked packs. No more sitting down and counting and dropping them on the floor. You remember, it's not fun. I didn't like it. So now they'll do it for you. Safe, sealed, and dated. So call Your Pharmacy and Mobility Solutions at 951-845-8252.
The following is a paid program. Views and claims expressed are those of the program producer and are not endorsed by this station. Opinions expressed are not necessarily those of radio station KMET, its management, employees, or affiliates. The WK Law Power Hour is here to take you from zero to hero in legal knowledge in 60 minutes. A law firm with 40 years of experience is ready to give you legal guidance you need for free. What could be better than that? Amazing stories about actual cases, interesting and informative guests. Listen, watch, call in. Come ready to learn. And now your host for WK Law Power Hour, Paul Wallin.
Good afternoon, everybody. I'm coming to you from Las Vegas, Nevada. After no vacations for almost 2 years because of COVID, I just had to have an opportunity to get away, but that does not stop me from being the host of the WK Law Power Hour. The whole purpose of our show for the last 16 weeks has been to educate people and to increase their legal knowledge, because legal knowledge is power. We try to take you guys from zero to hero in 60 minutes every week, as it relates to your legal knowledge to protect yourself and to impress your friends. Free legal advice. What could be better than that? Another way to get free legal advice is to call our office toll-free, 877-466-5245. That's 877-466-5245. Or you can follow us on TikTok at Beats Lawyer Paul, or you can obviously go on our websites. We have many websites. Our main one is wklaw.com. We have been a law firm for over 40 years. I happen to be the senior partner of our law firm, and we have offices throughout all of Southern California. The purpose of the show is to keep you guys updated on all legal happenings that are going on in the USA and to discuss them with you. Today, obviously, one of the hot topics that I've been discussing on TikTok for at least 2 months now is what are the legal ramifications to the government and businesses in an attempt to get people vaccinated. Today, California announced a very big milestone. 80% of Californians 18 and older are now at least partially vaccinated. And that is obviously one reason why California's overall infection rate with CV-19 is much lower than most states. We know that in states that are marginally vaccinated at rates at half that level or a little more, the rates of hospitalization and people being in the ICU and deaths are very, very high. So the question is, what can and cannot be done legally to get people vaccinated? And we'll be talking about that later in the show in more detail. But a good question is, how can we keep unvaccinated people out of the military or keeping them from getting into the military if they won't be vaccinated? And the answer is because the government passed a law. President Biden and the Secretary of Defense said, unless you're vaccinated by the 15th of September, you can no longer stay in the military unless you take weekly tests to make sure you're not positive with the COVID. And of course, the reason is we don't want the military overrun with infections of COVID because we need them to defend our country. Another very important thing, of course, is keeping people out of colleges and universities if they refuse to be vaccinated, because we don't want our college students getting infected from people that aren't vaccinated. These are just two things that the government is doing that is not requiring you to get a vaccination, but is absolutely saying you are going to have consequences if you don't. So that's just some of the things we discuss on our program. Today, I have the tremendous privilege of having my law partner, Eric Jones, on our program, beginning to end, to talk about his defense of all kinds of criminal cases, from traffic tickets to DUIs to every kind of criminal case, and what is important to know if the police get involved in your life. What do you need to know to protect yourself? And what if you get a DUI? What blood test should you take? And what should you say to the police when they ask you how much had you had to drink? Those are really good things that people should know, right? Well, we will answer those questions on our program. When you get legal knowledge from this program, we can help you answer questions like, how do I beat my traffic ticket? Should I go to traffic school? Should I fight it? Maybe the cop won't show up. And what if I'm going through a divorce? How do I do that? How do I make sure I get the most in child support or spouse support? And most importantly, how do I get my child custody rights? How do I keep custody of my children? Things that are so vital to so many millions of people in California. And that's the kind of things we address on our website and during this program. So feel free to call at any time, and we'll be more than to answer your question. And please, after the break, Eric Jones is going to be back, and we're going to talk about everything law. So please hang in there. And if you have any questions, 951-922-3532, we would love to talk to you. And now let's go to the break.
You've been charged with a crime, and now you're facing the loss of your freedom. Where do you turn to get out of jail or stay out of jail? The law offices of Wallin Klarich. Call 877-4-NO-JAIL. With over 20 years experience and attorneys who work in your local courts, Wallin Klarich can make the difference between jail and freedom. When you need help, make one call. Make it to Wallin Klarich. 877-4-NO-JAIL. The call is free. Will you be?
Hey, are you okay to drive? Yeah, I'm fine.
17 to Central Jail.
If you've been arrested for DUI and are facing DMV in court hearings, it could mean losing your license, your job, and even your freedom. But Wallin Klarich can help. Just call 877-4-NO-JAIL. With attorneys who know your local courts, Wallin Klarich can make the difference between jail and freedom. Call Wallin Klarich at 877-4-NO-JAIL. The call is free. Will you be?
When your children are taken by social workers, it may be the worst day of your life. When will I see my children again? Where are they going? How can I get them back? Who can I turn to for help to end this nightmare? The answers to all these questions are a phone call or email away. Wallin Klarich have been helping defend parents who are battling the system to regain custody of their children for 40 years. Many of their clients have done nothing wrong to warrant their children being taken from them. Other clients may regret some action that they've taken with their children. However, in every case, the clients desperately need their children back. That's where Wallin Klarich comes in. They know the dependency system. They will do all they can to work to try to get your children back with you. Take the first step and call Wallin Klarich now for a free phone consultation at 877-466-5245. That's 877-466-5245. Or visit wklaw.com to chat with us. They'll be there when you call.
If you are facing criminal charges, your entire future is at stake. You need to act now to protect your job, your family, and your freedom. Call Wallin Klarich at 877-4-NO-JAIL. Wallin Klarich has over 30 years of experience in fighting for our clients' rights. With local offices in Riverside and San Bernardino, we are here to help you now. Call 877-4-NO-JAIL or go to wklaw.com. How much is your freedom worth? Call 877-466-5245. The call is free. Will you be?
When you have a warrant for your arrest, it's a very scary time in your life. When you drive a car, you have to be extra careful that you do not commit any sort of moving violation. You have to be looking over your shoulder, checking for police officers. Will you be stopped and thrown in jail? What a horrible feeling. For over 40 years, we have helped thousands of persons resolve their problem with having a warrant. In some cases, we can actually appear in court for you without you being present to recall the warrant. Depending on the facts of your case, you may never have to do 1 minute in jail. Stop living in fear. Call us now for a free phone consultation at 877-4-NO-JAIL. That is 877-4-NO-JAIL. Or go to wklaw.com. Isn't it time to get your life back? We will be there when you call.
Okay, everybody, we're back. WK Law Power Hour. It's my tremendous pleasure to introduce Eric Jones, one of the partners at Wallin Klarich. And we're going to talk about Eric's background first, so you get to know what a passionate person he is in his defense of people who need our help. Hi, Eric.
Hi, Paul. How are you today?
I'm fine. So why don't we start, Eric, by telling what kind of areas of law you handle at our law firm?
Primarily, I handle criminal defense, juvenile dependency, and I do some restraining orders as well. Those are primarily the three things that I do.
And just give us an idea of the type of criminal cases from one end of seriousness to the other that you might handle.
I mean, it runs the whole gamut from low-level misdemeanors, DUIs, domestic violence cases, shoplifting, petty theft type of cases, all the way to serious violent felonies such as assault with a deadly weapon, different levels of homicide, burglaries, robberies, gun crimes. It just really runs the gamut.
So just about anyone accused of a crime you would take on their case on behalf of our law firm. And our firm, of course, has many offices throughout Southern California. I think we cover an area of almost 16 million people who are within 20 minutes of one of our offices. But why don't you tell us what offices you work out of and meet clients in?
I primarily practice here in San Bernardino County. So I have an office in San Bernardino near the courts. And there's also an office in Victorville, which is also a little further from the court, within a half a mile or so. But those are the two offices I primarily work out of. Occasionally I'll go out of county and handle some cases in Riverside, but my primary practice is here in San Bernardino County.
Can you talk about the importance of someone facing a criminal charge to hire a lawyer like you who is so close to the courthouse and goes to the courthouse, those courthouses in Victorville and San Bernardino very often? Why is that important for the person deciding who to hire? Why is that beneficial?
It's beneficial for a lot of reasons. It could probably be down to familiarity with the people at the courthouse, the judges, the district attorneys, if you're doing criminal defense, the procedures. Every courtroom is different. And, even though the laws are uniform throughout the state, it varies from county to county and even courtroom to courtroom how different cases can be handled. And so really the only way to learn that, it's not something they can teach you in school. It's something you gain through experience and through practicing in the court consistently. And also, as another benefit, when you're constantly going to the same courts, seeing the same people, being in front of the same judges, you build up a reputation, and that is important as well in choosing an attorney. You want an attorney that has a good reputation in the court that you're practicing in and is familiar to the people there, because it breeds a level of trust when you're working with other people.
Very often we'll get a call from someone and they have a case pending in the Victorville court, and it's serious. It could be domestic violence, or it could be worse. They could be facing prison time or jail time. And they'll say they were thinking of hiring a lawyer from Los Angeles or in the San Fernando Valley. Why is that probably not the best idea?
It's mainly going back to what I said earlier. That attorney probably does not practice very regularly in the Victorville court, if at all. And as a result of that, he's not going to know kind of the prosecutors up there, the judges, how things work. There's a certain amount of navigating the bureaucracy that comes from experience and knowing kind of like the range of outcomes that are possible on a case, given what the facts are and who you're working with. And that helps inform your strategy. So, it's really valuable to have local counsel. And, by the same token, like someone like me who practices primarily in San Bernardino County, I wouldn't be the best choice to handle a case in downtown LA or in Ventura or something like that, because
exactly. And that is why our law firm has lawyers that have tremendous experience in the courts in Los Angeles and in Orange County. Those lawyers work out of offices close to those courts. That's how our whole firm operates and was created, to provide lawyers for people that are facing serious or moderately serious criminal cases, because basically anyone facing a criminal charge, to them, that's the most serious thing that could have ever happened to them. They need a lawyer who knows the court and the judges and the DAs and, as you say, the procedures. And that's why we have our offices set up exactly that way. It often boggles my mind when someone pays a lawyer $15,000 in Los Angeles to go out to Victorville, because part of that money is travel time, because he's got to drive all that way for every court appearance, let alone not knowing the court. So Eric, let's talk more about your background. First of all, where'd you go to college and law school?
I went to college here locally in Los Angeles, UCLA, go Bruins, LSU this weekend. And then I went to law school out of state. I went to actually Midwest, University of Nebraska College of Law in Lincoln, Nebraska, and I graduated law school in 2009.
Okay, wow. So you've been a lawyer for like 12 years?
Yes.
Okay. And how many years have you been with Wallin and Klarich?
I believe it's coming up on 8 next month.
Wow, that's a long time. Can you tell me, of all the areas of law that you could have practiced and can practice, why is it that you choose to practice criminal defense and child dependency law?
I think it's because I like working with the clients, working with their families, helping try to make sure that the system treats them fairly. There's a lot of bias or prejudice in the system, and there's assumption of, even though you're presumed innocent in the eyes of the court, in the eyes of the judge, the system really does kind of presume that you're guilty if you're accused of a crime, and there's a lot of stigma that goes along with that. And some people get falsely accused. Some people, there's exculpatory evidence. So I think it's really important to help people in those positions in order to make sure the system treats them fairly, and that someone who's innocent, or at least there's not enough evidence to meet the burden that the state has to prove their guilt, is not unfairly convicted by the system. There's a saying, it's better to let 100 guilty people go free than convict one man. I think at its core, that's kind of what a lot of my motivation is for doing what I do. It's make sure that things are fair and that the system is fairly.
There are so many lawyers who want to practice criminal defense, but do not have the passion and the compassion. That's what I have found more than anything else. When I created Wallin and Klarich 40 years ago, it is hard to believe I did so specifically because I wanted to help people who were in distress. I just couldn't be the kind of lawyer that would sit behind a desk and read a 60-page contract or try to figure out a property case or something that really, to me, this was not important because it was just about money. I wanted to get involved with people and help them through a crisis in their life. And that's why I gravitated to criminal defense. People that are often wrongfully accused, and even if they did commit a crime, we're their last hope. And so many lawyers will take advantage of those people in distress. We go out of our way to make sure that they understand that they're hiring us so they can just talk to someone about their case, just get an answer to their questions when they call, not wait 3 days, 5 days for an answer. And with Eric, he's a perfect example of that. If you ever wanted to know whether you're getting the right lawyer with Eric Jones, you can just check on Yelp or Google or avo.com or any of those things. He's got a tremendous amount of positive reviews. And of course, he gets great results, but I think what's more important is people say that he cares about their case. He knows the facts of their case. He understands the family dynamics. And Eric, I just want to say that is absolutely fantastic that you're that kind of human being that can because it's not every lawyer that can do this kind of work. So anyway, I wanted to thank you for that. Now, in terms of certain kind of crimes, I wanted to talk about them because we handle a lot of different crimes and some are extremely serious. One crime I'd like to talk to you about is the crime of child annoyance. It's Penal Code Section 647.6. Could you just first of all tell us what is that crime and how does someone get convicted of that crime?
Okay, so Penal Code Section 647.6 is termed annoying or molesting a child. However, molesting in this context means bother more than your typical thought of child molestation. That's a more serious charge. It's a misdemeanor, and so even though it's people might think, oh, it's not that bad, it's a misdemeanor, but it actually carries some rather serious consequences. And what the crime entails basically is having some kind of physical contact, or it doesn't have to be physical, I suppose, communication with a child that invades their privacy, invades their space, and then is also sexually motivated. That's the key. So it can be sending, and the child here is a minor under 18. It could be sending messages through electronic communications that are of a sexual nature. It can be something as simple as rubbing a minor's shoulders if that intent behind that contact, that physical contact, is sexually motivated. So a lot of the basis of the crime is based on the intent of the accused, and that's a big part of proving that crime that the prosecutor has to do.
If a person is convicted of annoying or molesting a minor as that crime, what kind of punishment can be imposed upon that person?
It carries a maximum sentence of 1 year in the county jail, a fine of up to $1,000 plus assessments, which makes the fines potentially a lot larger than that. And but most importantly, or perhaps most consequentially, it also forces a person to register as a sex offender under Penal Code Section 290. And under the current law, that would be a 10-year minimum registration period. So you're looking at having to register as a sex offender for 10 years and then potentially having that obligation stop after that.
What are the main defenses that we can raise in a case of child annoyance that have been successful in winning other cases for us?
Well, one of the big defenses, it goes to that the alleged conduct was not sexually motivated. Obviously, that's fact intensive. It depends on the facts of the case, what the evidence is, and doing additional investigation, trying to figure things out as the case goes along. So that's one of the big defenses, is that the alleged conduct happened, but it was not sexually motivated. Another possible.
No, go ahead.
And another possible defense is that the minor is not giving an accurate description of the events that occurred. So, which is, I guess, kind of a long-winded way of saying the minor isn't telling the truth. And so that's another possible defense. That's more of a factual defense. Sometimes these cases come down to a, he said, she said type of dynamic, but those are defenses that have proven effective in the past.
So in a case like this, a person could actually be prosecuted for squeezing the shoulders of a minor under 18 if it could be proven that that physical conduct was done at the same time because that conduct was sexually motivated, correct?
That under those facts, this crime could potentially be alleged.
I had a case that was very, very highly covered in Orange County where a prominent computer teacher was accused of 10 counts of misdemeanor child annoyance / molest. Obviously, he was suspended from practice of teaching, and he was facing many years in custody. And the allegations from 10 fifth grade girls was that he would come behind them at computer lab and squeeze their shoulders. And literally at the trial, they actually had a ruler where the district attorney asked the girls how close did his fingers, the tips of his fingers, come to their breast area. At that time, when girls are that young, it's like they don't even have breasts that have developed yet. And in my defense, I called 8 boys in the 5th grade to testify that he did the exact same thing to them, associated with good job, great job. He was just that kind of teacher. And the girls were sure that he did something wrong, but in reality, it wasn't sexual at all. And the jury came back 11-1 for not guilty after 3 weeks of his life and a year nightmare. And finally, the judge dismissed the last charge. But that's how crazy this crime can become and how it can ruin your life. So we're going to go to the break, and then after the break, we're going to talk about domestic violence and burglary, and it will be very important to hear your answers, Eric. So let's go to the break.
You've been charged with a crime, and now you're facing the loss of your freedom. Where do you turn to get out of jail or stay out of jail? The law offices of Wallin Klarich. Call 877-4-NO-JAIL. With over 20 years' experience and attorneys who work in your local courts, Wallin Klarich can make the difference between jail and freedom. When you need help, make one call. Make it to Wallin Klarich. 877-4-NO-JAIL. The call is free. Will you be?
When your children are taken by social workers, it may be the worst day of your life. When will I see my children again? Where are they going? How can I get them back? Who can I turn to for help to end this nightmare? The answers to all these questions are a phone call or email away. Wallin Klarich have been helping defend parents who are battling the system to regain custody of their children for 40 years. Many of their clients have done nothing wrong to warrant their children being taken from them. Other clients may regret some action that they've taken with their children. However, in every case, the clients desperately need their children back. That's where Wallin Klarich comes in. They know the dependency system. They will do all they can to work to try to get your children back with you. Take the first step and call Wallin Klarich now for a free phone consultation at 877-466-5245. That's 877-466-5245. Or visit wklaw.com to chat with us. They'll be there when you call.
Hey, are you okay to drive? Yeah, I'm fine.
17 to Central Jail.
If you've been arrested for DUI and are facing DMV in court hearings, it could mean losing your license, your job, and even your freedom. But Wallin Klarich can help. Just call 877-4-NO-JAIL. With attorneys who know your local courts, Wallin Klarich can make the difference between jail and freedom. Call Wallin Klarich at 877-4-NO-JAIL. The call is free. Will you be?
When you are facing a serious criminal charge, it means you may be looking at many years in prison or doing up to 1 year in county jail. Most people do not know who to turn to in their time of need for expert legal guidance. What you do next can make the difference between ending up in prison for many years or having your charges dismissed and you going free. At this very critical time in your life, you need Wallin Klarich fighting for you. Wallin Klarich has 40 years of criminal defense experience, and they work very hard to do all they can to win their clients' cases. Wallin Klarich has a team of 10 criminal defense lawyers fighting for their clients every day. They help people with cases pending throughout California. They successfully defend cases dealing with murder, sex crimes, all felonies, as well as misdemeanors. Check out wklaw.com for some real client success stories. They offer a free phone consultation to answer your questions. Call them toll-free at 877-4-NO-JAIL. That's 877-4-NO-JAIL. They will be there when you call.
If you are facing criminal charges, your entire future is at stake. You need to act now to protect your job, your family, and your freedom. Call Wallin Klarich at 877-4-NO-JAIL. Wallin Klarich has over 30 years of experience in fighting for our clients' rights. With local offices in Riverside and San Bernardino, we are here to help you now. Call 877-4-NO-JAIL or go to wklaw.com. How much is your freedom worth? Call 877-466-5245. The call is free. Will you be?
Hi, everybody. We're back. This is Paul Wallin, WK Law Power Hour, and Eric Jones is our guest. Eric Jones is a partner at Wallin Klarich and a brilliant lawyer with our firm who handles cases in San Bernardino County for our firm, everything from a traffic ticket to a very serious felony. And what we're talking now about is probably the one crime we handle more than any other crime, maybe other than DUIs, is domestic violence. And domestic violence, a person accused of domestic violence is just as likely to live in Beverly Hills as they are in Watts. There is no correlation between race or economic standing or sexual preference. Domestic violence happens everywhere, the most affluent neighborhoods and the poorest neighborhoods. And we're going to talk about how someone gets arrested for domestic violence, the consequences of that, how we successfully defend people accused of that crime, how we get people help who have committed domestic violence, because it's a horrible crime and should never happen. So Eric, why don't you first tell us how many domestic violence cases would you say you have handled with our firm?
I've never really kept count, but I'll roughly say in the hundreds.
Hundreds, and our firm has probably handled easily 5,000 domestic violence cases in all our various offices. Now, why don't you tell us what are the elements of domestic violence in the first place?
So, I mean, there's a couple of different penal code sections that encompass like the domestic violence laws, but roughly speaking, you have to have some kind of dating relationship or a married relationship, or it could even be a former spouse. At some point in the time that the other person, there had to be some kind of romantic relationship between the two of you, either existing or formally. So that's one that creates the domestic relationship. And then,
just 1 second. So to be accused of this crime, the victim needs to be someone you were in some kind of romantic relationship with, or could it be just living in the same house, or what?
There has to, well, I mean, it has to be more than a roommate situation, right? Because then that doesn't meet the domestic part of it. There has to be some kind of relationship between the two people, the accused and the alleged victim. But it doesn't have to be existing at the time the alleged conduct occurred, right? So it could be an ex-husband and an ex-wife, and they've been divorced for 5 years, and then there's an association between them, and because of that former marriage, the person who's accused of the violent act could be charged under the domestic violence statute rather than just a battery or something along those lines, where you don't actually have that relationship with the person.
Okay, how does the district attorney prove the crime in a case, if they can prove the crime, where the alleged victim calls 911, but then says, I changed my mind and I don't want to testify against the person?
Well, so they can still potentially prove that case under those circumstances. Again, it depends on the facts of the particular case. But for instance, if the alleged victim refuses to testify, obviously they can't call them at trial to testify because they're not going to say anything. So then it becomes a matter of, well, what other evidence do they have? Well, they have the 911 call. And a lot of times that's going to be admissible evidence under, it will fall under an exception to the hearsay rule. So they could potentially play that tape at trial. A lot of times there'll be photographs of the, alleged injuries. So those would be admissible at trial under most circumstances.
I'm sorry. I wanted to bring something up that's really important. In California, there is a law that if you get subpoenaed to testify in a criminal case and you don't come to court, the judge can put your butt in jail until you testify. That would be contempt. But in California, if you are the victim of domestic violence or sexual abuse, you can refuse to testify even if you're subpoenaed, and the court can't put you in jail. They can order you to do classes, victim protection classes, but they can't put you in jail. So victims of domestic violence and sexual abuse in California and many other states have this power that I think makes it more difficult for a district attorney to prevail, because in other cases, the DA can say, fine, if you don't want to testify, you're going to sit in jail, and that can't happen in these cases. Is that right?
Yes, and I would just like to, because there's often a misconception about this, and I don't want any people listening to this program to get this wrong, if they're ever in this situation in the future, is that you can't just ignore the subpoena. I had this happen recently, and I had to help the person get out of it. I wasn't working on the domestic violence case, but it was an alleged victim who hired our firm because she had a warrant for her arrest. And the reason was because she didn't show up. She got subpoenaed. She was an alleged victim in a domestic violence case. and she didn't show up to the court date, and the court issued a warrant for her arrest. So having the right not to testify isn't the same as the right not to show up if you receive a subpoena. So you still have to.
Very important that you must honor the subpoena. You must come to court, even if you're the victim of domestic violence or sexual abuse. And when you get to court, then you can refuse to testify. If you just blow off the subpoena, you're going to get arrested and go to jail. That's important to know. In an extremely high percentage of cases, I take a very high number of new client calls at the firm, and at least half of those calls are coming from the victim, him or herself. And by the way, a question, how many women get accused of domestic violence, you would be shocked. At least in our firm's experience, I would literally say 1 in 3 of our domestic violence cases are women. That has gone up over time, I believe, as women have taken a more equal role in our society. That wasn't the case when I was doing cases 20, 30 years ago. It is the case now. But it's shocking to me that in about half of the cases, the person calling is the victim who might have been in the hospital, might have been, broken a bone. And they're calling specifically asking, how can I get my husband out of jail? How can I get these charges dropped? And the number of excuses they make for the perpetrator is a very long list. And our job is to defend the client to get the best result possible. We're not social workers, but it's my experience that if we get our client immediately into therapy and anger management and get the wife into victim protection classes, number one, there'll be a better outcome in the case. And number two, hopefully in the future, this will not happen again. Basically, that's my philosophy, Eric. What's your philosophy on these cases?
Yeah, it's very similar to that. A lot of times there will be services available to, if it's a spousal situation, I always encourage, and they want to, stay in the relationship, then I always encourage getting into therapy, attending anger management classes, doing it outside the purview of the court. Even maybe before the first court date, right? Get that process started as soon as possible. Start working on these things, on these issues, so that nothing like this would ever happen again. But then even through the court process, a lot of times there will be, a counseling available to the defendant, and there'll be the district attorney's office has victim services, so they have services available for victims of counseling, therapy, and things along those lines. So there's lots of things out there to help. Sometimes, it's a one-off. It's not. I've had cases where they've been married for years and years and years. Neither party has a record, and then one time something happens.
Don't you find, Eric, that a tremendously high percentage of cases are because of the use of alcohol or some kind of drug?
And I was just going to get into that. And then usually there's a reason, and it's usually because someone has been drinking too much, an excessive amount of alcohol. And there might be a reason for that. They might be dealing with certain stresses in their life, and they're using the alcohol as a coping mechanism. There could be a recent traumatic event that happened in their life, such as the death of a loved one. It could be just stress that's accumulated over time from work and other things in life that causes us to have a lot of stress, financial problems, things of that nature. So, a lot of times, the clients that I'm helping in these cases fundamentally aren't bad people. They're just in a bad spot in their life. And so part of what I see as my job in a lot of these cases is to help people get back on the right track. And, in addition to making sure that the system treats them fairly, so they don't have to come back into the system.
I think people I think people, what you brought up about not bad people, people need to understand that this crime, as I mentioned earlier, is across the board. We've represented sheriffs, we've represented marshals, we've represented judges, we've represented teachers, we've represented every walk of life, CEOs. It's this crime. And one thing that I always stress right off the bat, when a person, the first time they say, we have been drinking, he had been drinking, she had been drinking, I tell them straight up, I want to find out what their history is. Do they have prior DUIs? Do they believe they have an alcohol problem? And inevitably, if alcohol is involved or drugs involved, it's so important that we get them involved in AA, get a sponsor, or NA, and start working the problem well before we get in front of a judge. Don't you think that's important?
Yes, you definitely want to try to treat, or not necessarily treat, but direct the client to resources to help them treat and get the underlying issue, especially when it's substance abuse. And there's so much of an intersection between not just domestic violence, but also all types of different criminal conduct that gets alleged, and some issues. And so sometimes treating those issues gets to the root cause of what's causing the person to come into contact with the criminal justice system in the first place.
Now let's talk about the punishment and all the consequences that happen to someone who is being accused of domestic violence. And why don't we start with the temporary restraining order, or what happens, criminal protective orders? Why don't we talk about that and how that impacts the life of the defendant and his significant other and the children and all that?
So, initially, there's usually going to be what's called a criminal protective order issued at the first court date. Sometimes it's even a temporary one is issued at the time of arrest, which will last for a few days. So that criminal protective order can potentially say that the defendant can't have any contact with the alleged victim while in effect. So basically for the duration of the case. And then there might be another one issued at the end of the case if the defendant is indeed convicted of the crime. So it can cause, basically the person to have to find another place to live if they live together. Then also that could, potentially cause them to not have any contact with their children, or very limited contact with their children, because if the other parent, who's the alleged victim, is with the children all the time and you can't have contact with that person, then you're not going to be able to have much contact with your kids either. If you have to move out of the residence, you're not going to be able to have as much contact with your kids. So it can be, obviously very severe short-term consequences to the family dynamic, even before there's any, conviction in the case, or the case has even been litigated to, a significant extent. It really varies on the level of the, what's the seriousness of the domestic violence crime, because not all of them are the same. There's basically like 3 different statutes that cover this. And there's the 243(1) of the Penal Code, which is a domestic battery, and that doesn't require any injury.
That's a misdemeanor, right?
Misdemeanor. It's basically the lowest level of domestic violence under the law in California, and it's just a battery. And a battery is just harmful or offensive contact with another person, but it doesn't require an injury. It can be a push, a shove, slapping someone. Leaving a red mark, but it fades away. Those are all examples of batteries, and but that can carry the same criminal protective order consequence, where you can't have contact with the other person for the duration of the case. And then the next level up would be Penal Code 273(5), which is corporal injury, and that does require an injury. And depending on the severity of the injury, that crime can be a misdemeanor if there's an injury, but it's relatively minor, or it can be charged as a felony if the injuries are more serious.
What is Eric, what is the punishment for a conviction for felony domestic violence and misdemeanor domestic violence?
So the misdemeanors carry a maximum of a year in county jail. As you know, and then there's other things that go along with it. Oftentimes you're put on probation, unsupervised probation, where you don't have a probation officer. You'll have to pay fines. That varies from county to county, even sometimes court to court. But out here in San Bernardino County, those come out to about $1,000 to $1,100 as the minimum fines. You have to do a year-long domestic violence batterers treatment program that lasts 52 weeks. You go once a week for 52 weeks. That's required by law on domestic violence, lowest level of domestic violence. And there can also be a restraining order put in place by the court. And again, it can prevent you from having contact with the other party, with the alleged victim in the case.
So if someone is convicted of domestic violence as a felony, it's mandatory that they do 52-week batterers program, correct?
Felony and a misdemeanor. Either one requires that.
Even if it's a misdemeanor. And if they fail to complete that batterers program, then that's a condition, that'd be a violation of their probation, and that would mean they could be sent back to jail, correct?
Correct. For up to the maximum term of the crime you've been convicted of. So for a misdemeanor, that's up to 1 year.
And it is so important to understand that the reason the person's being put on probation for that is because they admitted that they did this act, and this act caused some harm to the victim, and that we don't want that to happen again. The court system doesn't want it to happen again, and no matter how much you don't want to do that class, that program, you should not plead guilty unless you understand that you're going to have to do that. And a lot of times people just want to get the case over with, and we tell them up front, it's just not that easy because it's 52 weeks. And everyone needs to understand that, right?
Yes, and there's no discretion. It's not a situation where the judge can say, oh, I'm not going to order that for this particular case because it was very minor or something along those lines, or the prosecutor can drop it. It's required by law that you have to do that class if you're convicted of either one of those domestic violence statutes that I mentioned earlier, misdemeanor or.
Okay. Is there another impact regarding your gun rights? If you're convicted of this crime, what is the law about giving up your rights? In fact, if you're arrested, what is the consequence of any guns that you have?
So generally what's going to happen is on arrest, law enforcement is going to seize the fire. If you have any firearms, they're going to seize them and hold them. Two reasons. Mainly it's because of the temporary criminal protective order that gets issued. That has a ban on owning, using, or possessing a firearm. So if you have firearms possession or licensed to you that you own lawfully, those are going to be taken away by law enforcement, or you're going to be asked to surrender them to law enforcement.
And they have to be destroyed. And in fact, if you're convicted of the crime, those weapons you'll never get back, correct? They're destroyed?
They can be destroyed. You can potentially transfer the title to someone who can lawfully own them. But you're not going to be able to have them back. Yes, if you're convicted of any domestic violence crime. So the law in California is, if it's a misdemeanor, typically it'd be a 10-year ban on owning, using, or possessing a firearm. Felony is always a lifetime. No matter what felony you're convicted of, you can't have a firearm for the rest of your life.
Wow.
But here's
wait, we only have, the show's running out. I just want, Eric, I want everyone to know, if you have a domestic violence case, you need someone like Eric Jones and Wallin and Klarich at your back. I want to thank everyone. Thank you, Eric, for being on the show. We'll see you next week, and have a great week, and keep learning the law.
Thank you, Bob.
Sure.